this unit, we will be looking at the constitutional developments in the areas relating to constitutional provisions in favor of Dalits and other backward classes. Why is it important to look at these developments? The reason behind us going into these developments, which will mostly be judgments of the Supreme Court, is that the Supreme Court, with the passage of times, has changed the way we look at these provisions and the way we understand and appreciate the full force of the constitutional provisions relating to the upliftment and betterment of scheduled castes. Why is it that the same words mean different things when looked at in different times? The reason is very simple. Constitution is not like usual legislation. A constitution is an organic document. A constitution develops with the society. It grows with the society, and therefore it is interpreted keeping in view the best interests of the society which it seeks to govern. We have previously seen the provisions that have been enacted in favor of the scheduled castes. However, it is also very important to see how the Supreme Court has interpreted these provisions to fully understand what effect this has had in the emancipation of Dalits in India. One of the earliest constitutional challenges faced was in the case of Champakam Durairajan. In that case, where the court struck down the communal government order which fixed the proportion of students of each community who would be given admission to medical and engineering colleges, the issue was raised in the court against that order. The court felt that though the directive principles of state policy prescribe measures to be taken for the welfare of scheduled castes and scheduled tribes, these directive principles stand subordinate to the fundamental rights which prescribed equality and non-discrimination. It may be pertinent to point out here that at this point of time, Article 15 of the Constitution, as it was before the amendment, did not explicitly provide for special provisions for scheduled castes and scheduled tribes. It was through the first constitutional amendment that the Articles 15.4 and 15.5 were added to the Constitution, providing for the addition. The changes brought about in the case of Article 16, which provides for equality of opportunity in matters of public employment, are of also much importance. As you can see in the previous case which we have just stated, in the case of Champakam Durairajan, it is clear that the courts took what is called a textual view of the Constitution. They stuck to the precise words of the Constitution. The courts did not allow the government to take a proactive step. This was remedied by a constitutional amendment. However, the courts since then have become much more open in their interpretation of the Constitution, and though there are various views regarding this change in the method of interpretation, it is widely acknowledged now that the courts take their own view also along with the bare text of the Constitution. Reverting to Article 16, as I have said, the changes brought about in the case of Article 16 are of immense importance. Even in the case of Article 16, the provisions did not explicitly mention that special provisions could be made in favor of scheduled castes. Such a provision was inserted by way of amendment later on. In 1995, taking into consideration the fact that it was not sufficient to have reservation at the level of selection and appointment alone, but was also required, but reservation was also required in the matter of promotion, the 77th Amendment to the Constitution was passed, which brought in reservation in matters of promotion also. This came after some back and forth in the cases of General Manager versus Rangachari, where the court had upheld a special provision which provided not only for adequate representation at the selection level, but also at the promotion posts. This position, however, was overruled by the Mandal Commission before the 77th Amendment reverted back to the old position. However, this made for a clumsy system, as this was interpreted as being a special provision in matter of promotion alone, and that it did not confer the accelerated seniority upon the officers who were thus promoted. To remedy this confusion or unintended interpretation, the 85th Amendment was passed in 2001, which clarified that the state is allowed to make special provisions in the matter of promotion with consequential seniority, and it was further clarified that the seniority would also be appropriately increased along with the promotion by reservation. A similarly related matter was addressed in a much earlier case. This case was Devadasan versus Union of India in 1964, where it was pronounced upon, where a judgment was taken upon the carry forward rule. Before this case, in the case of M.R. Balaji versus State of Mysore, the 50% rule had been laid down, which said that the total reservation cannot exceed 50% of the total strength of the cadre. However, in the case of some recruitments, due to carry forward rule, this limit was being breached. The carry forward rule simply meant that if seats reserved for a particular group went unfilled in a particular year, it would be carried forward to the next year and would not be filled up by candidates from categories other than the reserved category. This rule was modified slightly in the case of Indira Sahni versus Union of India. This is a landmark judgment, and this is also known as the Mandal Commission case. At this stage, let me give you a brief review over the Mandal Commission. The Mandal Commission was set up around the 1979 to identify backward classes as mentioned in the provisions of Indian Constitution. These backward classes were sought to be identified and benefits were sought to be conferred on them. Mandal Commission reported back, and Mandal Commission identified certain castes as backward classes, which were then known as other, which then came to be known as the other backward classes or OBCs. These classes were sought to be given protection. However, this protection was challenged in a court of law after widespread agitation across the country. Finally, the decision of the Supreme Court, taken by a very large bench, laid down certain rules regarding grant of benefits to other backward classes. The court held that while granting reservations, an upper ceiling of 50% has to be maintained. The court held that while calculating this 50%, it was not the cadre strength which is to be taken into account, but the total vacancies of a particular year that was to be taken into account. All of this was changed by the 81st Constitutional Amendment, which unequivocally affirmed the carry forward rule and said that irrespective of the 50% rule, the seats reserved for a particular group could be carried forward to the next year if they went unfilled in the previous year. Later, the scope of Article 16(4) has been further explored when it was declared that making special provisions for the scheduled castes under Article 16(4) was not an exception to the general rule of non-discrimination under Article 16, but rather the rule of non-discrimination would be fulfilled only if these sections of society were treated under special provisions to bring them on an equal footing with the rest of the society, and thus the special provisions were indeed an integral part of the principle of non-discrimination. It would appear that this approach has not been supported in the case of the P&T Scheduled Caste Tribe Employees Welfare Association versus Union of India, where the court held that Article 16(4) is only an enabling clause and reservation cannot be claimed as a matter of right. We have so far looked at the more important cases relating to reservation granted to scheduled castes. We have also seen that this has been an area of considerable litigation and considerable questions have been raised in this regard. What have been the reasons, what have been the causes for propelling these issues again and again? It is a fact of general knowledge that reservations have been an arena of immense political activity. Reservations tend to grant a great ease in achieving better life chances, as reservations assure an easier entry into various governmental positions. However, it needs to be understood that the reservations are meant for those who have been historically wronged and those who need to be brought up at par with the rest of the society. Whenever and in whatever form these reservations are used as mere political tools as opposed to instruments of upliftments of sections which are truly dispossessed of rights, they actually harm the system more than helping it. What is important is that the reservation, the policies of effective action, of affirmative action, must directly target the lowest and the downtrodden sections of the society and should help them come at par with the rest of the society. What should not happen is a misuse of the reservation provisions to strengthen the pre-existing stranglehold of certain groups in society. Let us move on to other matters relating to these constitutional developments. The list of scheduled castes as per the presidential order can be amended from time to time as the circumstances may require. However, it has been settled by a constitutional bench in Ashok Kumar Thakur case, where it was held that creamy layer system could not be applied in the case of scheduled castes. The creamy layer system is a system which was devised in the Indira Sahni case, where it is thought that even within these castes there are persons who, due to their position in society or economic power, are not subject to the same disabilities as their peers, and due to this they would be shutting out the persons who really deserve the reserved positions. Let me explain this to you by an example. Let us assume there is a group which has been granted reservations in government employment. Let us assume this group is not a homogeneous group in terms of their economic strength or in terms of the availability of life chances to them. Thus, in this group there is a hierarchy internally. Let us assume that the highest person in this hierarchy, the highest family in this hierarchy is family Z, and the lower family in this hierarchy is family A. If family Z is given the same protection as family A, family Z is obviously, because of its pre-existing strengths, going to usurp the benefits which come through the reservation system. Thus, if family Z, which is richer, which has the ability to send its children to better schools, to provide them better education, is pitted in competition with family A, which might not even have enough food to eat, the benefits of reservations are entirely going to go to that section which has pre-existing capabilities. To avoid this, and understanding that in certain sections in Indian society this is reality, this is existing reality, the system of creamy layer was brought in. This system is used in the reservation for other backward castes, where if the parent of the person has an income of 4.5 lakh per annum or more, or if they are holding a constitutional position, or they fulfill some other criteria, they become ineligible for availing reservation. Thus, you can understand that the system of creamy layer intends to ensure that only those who do not have access to life enhancing opportunities get them, and not those who already have the same opportunities and they do not usurp the opportunities which should belong to the downtrodden sections. At this stage, it is important for you to know that the creamy layer system applies only with other backward castes. It does not apply in reservations available to the scheduled castes and to the scheduled tribes. The reason behind that is that there is that the Supreme Court did not find any constitutional provision which would justify the imposition of a creamy layer category. We now move on with our discussion relating to constitutional developments regarding scheduled castes. The scheduled castes are determined by presidential order under Article 341, which is declared after consultation with the governor of the state for which it is issued. In the case of Parashuram versus Shiv Chand, it has been held that whether a particular caste is a scheduled caste is to be determined on the basis of this public notification and not on the basis of evidence that may be observed by the court. That is, whether a caste is a scheduled caste or not is an executive decision, and it is not open to the court to examine whether the caste is a scheduled caste or not. Let me make this point further clear to you. Let us assume that caste X and caste Y both seek a position as a scheduled caste. Let us assume that the government has put caste X as a scheduled caste but not caste Y. Caste Y may not go to a court and ask and seek its inclusion in the scheduled caste system through a judicial decree. This is a power which lies with the government. While its proper exercise may be inquired into by the court, it is not for the courts to determine which castes are scheduled castes. However, once a tribe or caste is mentioned in the presidential order, the court can determine whether a particular person belongs to that caste or tribe or not. This principle was laid down in Bhaiya Ram Munda versus Anirudh Pathar in 1970. Another important question that arises here is that of conversion. That is, does a person continue to be a member of a scheduled caste if he converts to another religion? The idea behind the question is that caste is primarily a feature of Hindu society. In the case of C.M. Arumugam versus S. Rajagopal, the petitioner had converted to Christianity and had reconverted to Hinduism. Here, the court rightly held that the question to be determined here was not the practical effect of the conversion and not the theoretical or the theocratic effect. This means that it is of no consequence whether theologically he belongs to this community or that. It is to be seen if practically he continues being a member of the caste which was among the scheduled castes. It was seen that in many cases, despite conversion, the person continues to be a member of the same community, and socially his identity is still seen as being part of the same caste, and thus he is considered part of the scheduled caste and is treated as such. However, in the case of Swigaradose versus Zonal Manager, Food Corporation of India, in 1996, it was held that when a man converts to Christianity, his children cannot be considered to be part of the scheduled castes. There was confusion in this regard when in Punjab Rao versus D.P. Meshram, the court held that even when a person had converted to Buddhism, he ceased to be a member of the scheduled caste. This was because the presidential order said that only a member of the Hindu or Sikh religion could be a member of the scheduled caste. Later, the presidential order was amended to include the Buddhist religion. An important change came via the 73rd and 74th Amendments. This was a sea change brought about in the system of local self-government in the country. There were Panchayati Raj institutions in many states before this amendment also, but by this amendment, reservation for scheduled castes and scheduled tribes in the panchayats and municipalities was made mandatory by virtue of Article 243D and 243T respectively. These constitutional developments must be seen in conjunction with the pre-constitutional developments which have brought us to where we are today. By this, we mean the constitutional developments that are relevant to the study of position of Dalits in India when that happened before independence. The depressed classes had long found a voice of their own in two major fora. One was the Harijan movement led by Gandhi and the Congress, which was more integrated with the mainstream of the freedom struggle. The Congress and Gandhi had taken up a program of societal reconstruction along with the struggle of independence. The name Harijan, meaning God's own people, was a name given by Gandhi. The other was the Ambedkarite Dalit movement, which aggregated persons of the depressed classes, as they were then known, in a bid to improve their lot within society. It was under this aggregation that the depressed classes were able to petition the then British government successfully for preferential treatment in some matters, as they felt that to club them with the caste Hindus would mean that they would not be able to climb out of the abyss into which the caste system had pushed them. The series of roundtable conferences in 1930 and 32 were meant to determine the mode of government in India. Considering the formula worked out through these roundtable conferences, Prime Minister Ramsay MacDonald brought the communal award, which gave separate electorates to different communities and decided the number of representatives each community would send to the Central Legislative Assembly and to the state assemblies. The depressed classes were also separated, and a separate electorate was accorded to them apart from the caste Hindus. Mahatma Gandhi was in Yeravda jail at the time, where he had been imprisoned for his role in the civil disobedience movement. He went on a fast in the Yeravda jail, forcing the leaders of the Congress, Hindu Mahasabha, and Dr. Bhimrao Ambedkar to hold talks to come up with a newer formula. The agreement reached at the end of these talks were known as the Pune Pact. Under the Pune Pact, a fixed number of seats in each province was reserved for the depressed classes. The depressed classes would elect a panel of 4 candidates, and the joint electorate would vote upon these candidates and elect a representative. The history of constitutional developments with respect to scheduled castes is a long one. It is hoped that it continues and culminates in a direction of improved life chances for the scheduled castes and the upliftment of the conditions in which they have to lead their lives. To conclude, we have seen how the post-independence India has been rife with much constitutional litigation regarding the mode and means of implementing the special provisions available to scheduled castes. However, you have to understand that while we might not be covering the other sections of society, such as the scheduled tribes and other backward classes, these two have also been areas of major litigious agitation. The reason is that reservations are not only a means of implementing benefit for people, they are also a major political issue. What needs to be remembered and what needs to be ensured is that these methods of reservation do not lead to increasing the stranglehold of certain sections. What is required is a judicious and properly implemented system of affirmative action which truly helps and truly targets the weaker sections and brings them out of the historical injustices which have been meted out by the caste system. More than the affirmative action, what needs to change is the availability of true skill building and true ability building opportunities to the people of these sections. It is not enough to give jobs to these people. What is far more important is that the people of the scheduled castes are given the opportunities to truly develop the excellence which they are in possession of, but which has been through millennia of suppression been kept in a state of suspended animation. Therefore, what we need is a policy of affirmative action which truly focuses and brings out the best in all individuals of society, regardless of which class and caste they belong to.